Chapter 1 deals with interpretation, application, objects. The definitions clause always is the first in our legislation, except for labor legislation, but it's there to define a common understanding. And it's preceded by some other words, and that's where we have the provision that says that we need uniform standards. I'm not going to delve into all the definitions. There are a few new ones, and some of the existing ones we've amended. It's there to provide greater clarity. Second one, the application of the Act. The Act's application can be extended by the Minister. So if there is an operation that is not covered by the definitions in the Act, the Minister has the power to make a declaration that a particular operation also falls within the RSR Act. We have new exclusions, because currently we have exclusions. There's a new exclusion that deals with cranes, and those are the cranes that you find in the harbors, where there's maritime legislation that applies that deals with safety. So that is why that is there. Chair, the objects, as I say, we focus on safety. And that is the first thing that we say is the object: to have safe rail operations, a modern, flexible and efficient regulatory regime, collaboration and participation, and harmonization of railway safety regimes of South Africa and our neighboring countries, because we want to see increased interaction between the different countries. We want to prevent the proliferation of laws, and that's where we said that our law is national and it's uniform. So that's where that little trick came in. We want not to have too many policies and things. So we're going to have a national rail master plan. The ultimate goal is to have effective functioning. Transparent, accountable, coherent governance. I think that speaks for itself. Those are the objects of the Act. Then the exemption, as I indicated, there's a very specific process to be followed. We very often refer to it as government in the sunshine, because we say that government is there to serve the people, and the people have a right to know what government does and how it does it. And therefore, and you will know this, in the Constitution we have the Public Protector and we have the Auditor General, etc. All of those are institutions and functions that safeguard the interests of the people. It looks after our interests, because after all, we pay tax so that government can operate. We have a right to know how it operates. So there's a process to be followed. It's open. People can see it. It's justiciable. The RSR input is mandatory. The Minister cannot grant an exemption unless the RSR has been given an opportunity to make input on that. The Minister is not bound by that advice, but the Minister has to consider it. And if the Minister receives advice but disregards it completely, it's justiciable. And somebody can say, well, the RSR made a good point, Minister, why did you not take that into account when you took your decision on whether or not to grant the exemption? The exemption is for a maximum of 3 years. You have to reapply if those circumstances still demand an exemption. So it's not automatic that it will be extended or anything. The maximum is 3 years. It cannot be given retrospectively. So I can't go and do something and then when I'm caught out, quickly run to the Minister and say, please give me exemption. It can only work into the future. And that is to safeguard the position of that. It may be withdrawn. If an exemption is granted on the basis of certain facts, and those facts then prove to be incorrect, or they misled the Minister, or they misled the RSR, it can be withdrawn. Obviously, we have administrative justice rules that apply, reasons, etc. All those things will be there. And of course, also, all exemptions have to be reported to Parliament, because Parliament gives the power to the Minister and Parliament therefore needs to monitor whether the minister uses it wisely or not. So there's a reporting function as well. Chapter 2 deals with the regulator itself, and I think it's fairly obvious what we needed to do there, the continued existence. Then the objects: to promote, regulate and report on safe railway and railway operations. And then it says you need to cooperate, consult, collaborate, also with your international counterparts, and then you need to monitor the impact of developments. And that's very important, because we don't want the RSR just to be reactive, only to say, okay, we'll wait until somebody comes and applies for a permit, and then if we see things don't work properly. We want you to be proactive as well. You are the experts. You are the people who have the knowledge and the insight, which I as an ordinary person could never have. The officials in the department that deal with rail, obviously they know a lot, but they don't work with it on a day-to-day basis like you do. And you will gain insights, and it's your function and duty to take steps to make sure that things that will be happening in future or that will create problems, that they are dealt with timeously. And so that is also a very important role of the RSR. Thank you, ladies and gentlemen. If we can resume. Chair, with your permission, we'd like to go on to Section 7 of the Act, which deals with the functions and powers of the RSR. And you'll remember earlier we said the rule of legislation, of interpretation, you can only do those things that you are empowered to do. So this is the empowering provision of what the RSR can do as an organ of state, as a body. Obviously, as a board, you have certain additional functions and duties and powers. The staff has certain functions and duties and powers. This refers to the RSR as an organ of state. First of all, it must be fair, equitable, transparent, efficient, and cost-effective. Whatever you do, these are the basic principles. Section 217 of the Constitution, as well as Section 195(1) of the Constitution. These are the rules that apply to all organs of state. And when you deal with another organ of state and they don't adhere to these principles, then you can refer them to their constitutional duty to do so. So in your collaboration efforts, etc., if they don't do these things that meet these standards, you should actually refer them to this. One of the important functions is to advise the minister and the department, simply because the minister, number one, a minister is a political appointee, not necessarily versed in the issues of transport, even less in the very intricacies of rail transport. As I was saying to somebody, when I came into this process, I thought, well, what's the big issue? You've got a train and you've got a train station and you get on it and there it goes. And only having worked with all these experts over the years, it's a totally new world. It's a big environment and there's specialist knowledge, and the minister does not necessarily have that, and the officials do not necessarily have it. It's a very important function to educate, and I don't mean that in a negative way, but to inform and to help people understand the importance of these things that you are doing. Also to Parliament, because when we went through the parliamentary process, it was obvious that many of the members of Parliament did not have the requisite knowledge of what it is you do and what are the problems you're encountering. It's always easy to say, we do this, we do that. And in legislation, I always remind myself, it's always easy to talk about the good things. You must regulate, etc. But the question is, but what if? If things go wrong, what happens? What needs to happen? Who's responsible? Who will act? Who will take action? And so it's important to advise Parliament and let them know what are the difficulties you are facing. Is your financing adequate? Is your knowledge base adequate? Are the people you are able to hire to work in the RSR adequate? Should you institute a program of bursaries so you have more engineers coming into your system? Whatever the case may be, I'm just making up examples. But it's good to have a good interaction with Parliament. I know in the past they've done visits to the RSR or site visits. It's important for people to understand what are the difficulties you are facing on a day-to-day basis. Support, promote and comply with national rail policies. As I said, the department will have a national rail planning office. It will have a national rail master plan. That will impact on what you do, and you have a duty to comply with it. Monitor, promote and enforce compliance. The enforcement aspect is very important there. You set standards, you prescribe standards, or it's done via the minister in regulations. Very important for safety. Conduct research and report on future developments. This is a very dynamic environment, new technologies, new processes, new procedures. Now also in the very imminent future, new operators. And not all the new operators are going to be good guys who have safety number one in their minds. It's a very challenging environment that you work in. Provide education and training, public awareness. I think that's very important. When we had the public consultation in these little towns and villages and dorpies, we could see that the people, and many people, especially the poorer segment of our population, rely on safe railways. And we have not always been providing for that. There was an elderly gentleman in the Northern Cape who said, you know, we had this village, there was a train coming through, now there's no train, so there's no economy where we live. So it impacts on people's lives. And it's important to tell them, but if there is a safety issue, if there is an unguarded crossing, or you have trains coming through that don't comply with dust regulations or whatever the case may be, report it to us and we'll act on it. People should know that they're not powerless. That's the beauty of our new dispensation in this country. People are not powerless. We have powers and we have institutions that can help us to make a better life. And then cooperation with our counterparts elsewhere. We want to see more trade. We want to see upliftment of people. And train and rail operations will assist in improving those things. Then the powers, I'm not going to go into detail. Section 7(1)(d) sets out all the different things that you can do. And it might be a good exercise just to list them and check them. But that's where your authority comes from. That is when you spend money on something, that is your authority. You must do this so you can take money that's given to you or that you generate yourselves and use it for that particular purpose. Important. Collaborate with railway industry associations. One of the main problems we encountered when we were doing our own consultation is that people in the private sector rail environment were complaining bitterly that things were happening and they were never consulted. And they did not necessarily disagree with everything, but they wanted to make an input. And therefore we brought that to the attention of the lawgiver to say that, well, you know, if there are industry associations, it's important to have contact with them, to talk to each other, because it's always possible to learn from them as well, or to understand the difficulties they have, or the challenges. The example I gave earlier of putting out a regulation to say all rail lines must be fenced. If there had been more interaction and thinking through all the implications, we might not have had that particular situation. So it's important to collaborate with other people who are in the same sector, in the same industry. Conclude cooperation agreements or arrangements with relevant organs of state. Important, you have an understanding with the railway police, an agreement or memorandum. It's important because obviously ultimately one must cooperate, collaborate. Collection and dissemination of scientific and technical information. I was amazed to learn that some universities have research facilities, etc., that deal with railways as well. And it's always important to take note of what they come up with and see what they can add to the environment. Collaborate on the evaluation and licensing of relevant safety critical grade positions. A number of people said to us, but you know, we've got SAQA, they can tell us that this particular qualification is good enough, etc. That might well be. From a point of view where you draft law, you don't know that. So we've said that in this is collaborate with those people, learn what they know. Transnet has a school of railways. They have certain experiences. It can only enrich the process because, again, coming back to the basics, our goal is the outcome we want is safety. It's all about safety. And that is why we collaborate and listen to others as well. Receive advice on and propose railway safety standards. When the minister makes regulations, and we'll get to the regulations a little later, the RSR input is extremely valuable. And you can proactively engage where you see there are gaps or there's a vacuum in terms of looking at certain issues. And then there are additional powers because certain sections specifically say, for this purpose you can do this and that. Let's look at the safety permit chapter. It also has a section that deals with changing conditions of the permits. So those are additional powers. So always check the specific section as well, over and above this general section. Now the board, and we can deal with some aspects a little later. In general, it governs and controls the RSR, and I highlighted the word control. And that is sometimes, and I must add, I've worked with many organs of state, many boards, many public entities. And at times you've had the entity itself and its board, each other grabbing each other by the throat, having a situation of a war room where I come into a presentation like this and the board sits here and the staff sit there and they don't talk to each other, and it's not a good situation. So we make it clear, the board controls the RSR. Ultimately, the buck stops here with the board. That doesn't say that the board can do as it pleases. We've dealt with that as well. You will see thematically in the legislation, there's always a balance. The minister can do certain things, but other things the minister can't do. Certain things the RSR can't do, but the minister can. Certain things the staff can do, but the board cannot. Or the board does certain things, the staff needs to do whatever the board says. So it's important to understand this principle. Because with a power, you always have a responsibility. If you exercise a power, you have the responsibility and the accountability. If things go wrong with this, let's say, and this is quite possible, we have a huge accident and a number of people have died. What will happen in Parliament? The opposition gets up and says, Minister, you are responsible, you are accountable, why did this happen, etc., etc. And depending on the individual, the minister will say, well, yes, I'm the minister, but I've got an RSR. So the RSR must do this. And then the journalists will phone up and say, who's the board? Why didn't the board look at this? And that's the correct question to ask, because the board controls the RSR. It has the accountability. It must stand up and explain. So that's why it's very clear. The board controls the RSR. And how does it do it? It oversees and exercises general control. And this is a very sensitive issue, but I'm going to put it on the table. Sometimes boards get involved with micromanagement. there's an application for a license. Then a board member phones up the CEO and says, you know, there's an application from so-and-so. I want you to expedite it and help this person. That's wrong. The board does not interfere with individual actions. That is the duty of the staff. And the staff will have to account for it. There's no problem in the board saying, staff member, please join us and explain to us why you granted the license or you refused the license. And there have to be good reasons. We have administrative justice. That's not an issue. But the board cannot micromanage. It doesn't control by doing the work of the staff themselves. It sets out policy, it sets out guidelines, it sets out directions, or it gives a general instruction. Permits are given when ABC is met, or whatever the case may be, but not on individual applications. That is not the job of a board. And it's a difficult thing to find that balance, and obviously standing here, it's easy for me to say do this and do that. I understand it's sometimes very complicated, but it's something we need to be aware of. The board has a particular function, it has a particular role, it has a particular accountability. The staff on their part have the same. And that's one of the reasons, we can get to that later, the CEO is a member of the board. And that is to ensure that there's this interface and a mutual understanding of what the position is and what the difficulties are, what the challenges are. The board is accountable to the minister and to Parliament, A, for its own actions and performance. You'll have a performance agreement with the minister, you'll do the self-evaluation, King 4, all those good things. But over and above that, you're also accountable for the actions and performance of the RSR. And why is that? Because you control the RSR. That's where the balance comes in. You control, but you account as well. And that's where we find the balance. You have to report to the minister from time to time, as may be necessary and relevant, and then to Parliament, at least once a year via your annual report, and there's some other instances in the Act as well. But if you see a situation arising that needs parliamentary action, you are absolutely empowered to approach Parliament to say, may we come and see you and report on ABC? Because you're accountable, you will be held accountable. That is very important to understand. Individual board members, you do not represent a specific interest. And this is a concept that sometimes creates problems, because we have, let's say, the operators of trains. They say, well, we want a voice in the board. And depending on what kind of institution that is, that might very well be a good thing to have. But in this particular instance, where we're looking at safety as a concept and as our ultimate goal, that is not the best way to do it. So we don't have board member A representing the operators and board member B representing the unions and D the taxpayers or what have you. We have people with expertise and knowledge, and they will vote on issues and they will do their work, looking again at the ultimate goal of improving safety. So that's very clear. You do not represent any particular interest or block or group of people. You may not act contra the RSR's interest. I think that's a given. You cannot go out and undermine the RSR. And second, lastly, you must act independently and with unfettered discretion. And this is not always very easy to do, because you are under pressure from people who have certain interests,
you have people who have expectations, etc. But again, your ultimate goal is to ensure safety, and you must take your decisions based on what your view is of how best to achieve that. You exercise independent judgment, Nobody can prescribe to you on how you must vote or how you must decide on things. You take decisions in the best interests of the public, because safety impacts on all of us. Even if we don't regularly use train services, the operation of train services in a safe environment
is for the benefit of all the people of this country. So your decisions will be taken on how do we best improve life for all the inhabitants of the Republic. You must conduct yourselves in accordance with the highest applicable standards of ethics and governance. I think that speaks for itself. I'm sure all of you have looked at the principles in the King IV report. There's a lot of information available on that. And then what happens when you disagree with the minister? And this is a scenario of which I can give you many examples where I've assisted either ministers or boards to resolve these issues. And there's no easy answer. And that is why in the Act we have not specifically made provision for that, because we need flexibility. Again, I refer you to Chapter 4 of the Constitution on cooperative government, also the legislation that goes with that, and then also your duty to operate in a reasonable way. That, of course, also applies to the minister. And the minister has certain powers, both in the Act and other legislation as well, to direct the board. But on issues where you have the duty to take decisions, it's your duty. And when we refer to unfettered discretion, it means if the minister says A, and in your conscience you believe that B is a better position, then you should vote for B. And if that clashes with what the minister wants, it's a difficult situation, but it's part of being a board member. You have a certain duty, and of course, I mean, you don't want to clash with the minister. We respect ministers of state, but you have a specific mandate, you have a specific duty, and your duty is to look at the best interests of all the people of South Africa. And we've had examples, unfortunately, where ministers have not always taken the best decisions. And it might take some fancy footwork, and I hope you resolve any issues, if there are any, because there will not necessarily be. But it is a difficult position, and all I can say is just do your job as board members. Then importantly, what the Act doesn't say is what are your fiduciary duties? And again, you might ask me, why don't we have the specifics there? We just say you have fiduciary duties. And that's because fiduciary duties, there's a body of law that exists on fiduciary duties. And if you read the King reports, they say a lot about it, and there are all kinds of guidelines and all kinds of things. But generally, some of those duties include the duty of care. You must be diligent in your work. You can't just come and sit and say yes whenever the chairperson says who's in favor. You actually have to engage and bring your expertise and knowledge to the table. I mean, that's why you were appointed. Duty of loyalty, you must prioritize the interests of this particular institution. I might not like the fact that PRASA does X or Y or Z, but if it's in the interest of safety, I must go against my own wishes and support the things that are the right things. Duty to act within powers, that comes back to what I said earlier. You can only do those things that you are authorized to do. So here we have the echo. This is exactly what we mean by that. Duty of prudence, you must exercise sound judgment when you take decisions. Your example of should we attend this particular conference in Pyongyang, North Korea? Sound judgment. Is it in the interests of the people? Is it in the interests of safety? If yes, then go. If it's not, don't go. King IV, as I said, has a lot on this. But remember, the PFMA is also lurking in the background, because the board is regarded as the accounting authority of the RSR. And the PFMA sets out a number of things that are applicable to an accounting authority, which this board is. And so some of your functions and your duties you will also find in the PFMA. Section 50 of the PFMA, these are the things you must do, and you will see they reflect those fiduciary duties. But then there are also other sections where they deal with expenditure, irregular, wasteful, fruitless, also unauthorized expenditure. And that's such an important part of what you do as a board, is to look at how the finances of this institution are being dealt with. And the CEO, the COO, and the other staff members have certain functions and duties, and you oversee them. You check that they do these things correctly. And if there's an audit report that says the RSR doesn't have this or that or the other, it is your duty as a board to call the CEO and the COO and have them account for the absence of that particular mechanism, whatever the case may be. So it's the work ordinarily that one does. So as I said, just have a look at the PFMA as well. The staff will assist on what all those particular aspects are. The composition, and this is this is fairly new. 7 to 13 members who collectively have extensive experience in and demonstrate knowledge of and acumen in the listed areas. And then we list them. You can have a look at them. But it says collectively the board must have those. So it's not going to appoint one person who is a technical expert on this. It can have more people that look at different aspects. But as a board, holistically, you must be able to deal with the particular issues that are remembered. 7 to 9 persons represent civil society. So there's a process where how we deal with that. Then the CEO is ex officio a member of the board. So if the CEO resigns or is fired, he or she is no longer a member of the board, and the new person will then take that place. There's an official designated by the Minister of Transport. There's an official designated by the Department of Labour. And if I say Department of Labour, I know it now has a better name, but bear with me. Then one SAPS officer designated by the responsible minister, obviously for the obvious reasons. So those 4 people sit there because they are designated. They are not chosen. They are not appointed by way of the public process, etc. So those 4 members are there, and then 7 to 9 members will be appointed. The majority of the members must be non-executive. Now, I don't think we have executive board members in the true sense of the word, but in case over time that develops, it's the proviso is that the majority must be non-executive. Now, the process has changed a little. The minister must invite nominations. And again, this comes back to the principle of government in the sunshine. It's an open process, transparency, all those values we have in the Constitution. And it means that any member of the public may be nominated. Anybody who feels that they can add to the process, they can be nominated. The minister has to consider all the applications received and then appoints the members. And again, the minister has the power, so the minister must account for it. Again, the balance that we talked about earlier. The department will publish the name of the board on its website. Again, government in the sunshine. The general public can know who are our board members who represent our interests on the RSR. The minister also informs Parliament, and that is where the balance comes in. So the minister appoints, the minister has the power to take decisions, but the minister must report to Parliament. And if Parliament thinks that things didn't go correctly, then Parliament has powers to intervene, and it will do so. The minister designates a chairperson and deputy chairperson. And then you have certain other provisions dealing with things like the annual performance agreement, board evaluation, performance targets, and then submission of the board minutes and progress reports. That is also, it's flexible, it depends on the circumstances. If there's a new initiative, if there's an international agreement that you are implementing, you will from time to time report to the minister, so that the minister knows what is going on. Term of office, and let me stress again, this refers to the new board under the new act. We will get to the interim position with your board a little later on. So in principle, you serve for a period of 3 years, and it can be renewed. So you can serve two terms of office, so it can be 6 years. Then there must be a 3-year break, and you can be appointed again. So in a span of 12 years, you can serve 9 years. And it's always there because there must be continuity, one needs to preserve knowledge, etc. But then subject to the board evaluation, those 7 to 9 members, at least 1/3 must retire annually. And the reason for that is, we come back to the DPSA principles, is to have turnover, but also to make sure that we don't lose a whole board in one go. So that when you have new board members, there are older board members who have been there, and we have the knowledge not sitting in a person, but in the board as a whole. And that's the reason for that. And we'll look at the implications in terms of implementation. Members are remunerated in accordance with the framework annually approved by the minister in consultation with the Minister of Finance. That's what Treasury wants. So that is there. And then the minister will also, in your agreement, your contract with the minister, when he or she appoints you, there will be terms and conditions relating to things like terms of office and whatever else. I think that is fairly standard. Just by way of making a side comment, the framework must be annually approved by the minister. Now, the way departments work is they initiate things and they write memos and it gets sent to the deputy minister and then to the minister, all of which takes time. Which means that officials in the department who initiate that process must do so timeously. And I would suggest that in a very informal way that you remind the DOT officials that they should initiate that process so that we actually have an annual determination. Otherwise, it gets pushed out, and unless there's a signature from the minister to say that your remuneration is increased by whatever percentage, you still get paid on the old scales, and you don't want that. And I don't want that as a taxpayer, because if you do your job properly, you should be paid properly. I have no problem paying people who do their job properly. So just as a side remark, bear that in mind, that these things must be done timeously. Your functions, you provide the governance framework for the RSR. Oh, sorry. Yes.
Sorry, on that point, your previous point, I thought that National Treasury is the one who...
Treasury is also involved because the Minister of Finance is involved, and that actually emphasizes the point that if you sense that they are not working on this, you should very informally remind them.
Oh, okay.
But the department will approach the National Treasury and say, okay, this is what the remuneration is, and we suggest that CPI is the standard for the annual increase. Do you agree? And if they agree, the minister says, yeah, it's fine. They send you a letter and to say, as from this date, your remuneration is increased by X%.
So similar when we realize that the complex of the work of the regulator meets with other specified regulator and we find that we are still underpaid, we go the same route to indicate to Minister, for Minister to indicate to National Treasury.
Absolutely. I mean, there's nothing stopping you from interacting with the department and making a suggestion on why the remuneration is inadequate. But you must also take into account that different organs of state have different mandates and do different work. And the involvement of board members in institution A are not necessarily the same as institution B. So there might be reasons for differences, but if you feel aggrieved, there's nothing that stops you from interacting and bring to the attention. Because, you know, sometimes, you know, it's always the easy way to say, okay, we use the inflation rate as the percentage for the increase, which generally isn't a bad idea. But there might be specific reasons why it's not appropriate. And if, for instance, you have additional functions that you didn't have before, that would be a reason why the increase should be more than merely inflation. But again, nothing stopping you from interacting with the department on this. But again, you must expect pushback from Treasury. It's their job to push back. It's a situation that you will deal with. The functions, governance, ensure that the RSR is efficient, effective, transparent, accountable, and complies with applicable law. So you will summons the head of the legal department and say, this is the situation, are we complying with the legal prescriptions in this regard? Or you will summons the COO or CFO and say, well, these are the new PFMA regulations. How do we comply? Do we measure up to it or don't we? And that is part of your overseeing the functions of the RSR. You determine and enforce the broad policy frameworks, and we'll get to some of them a little later on. And importantly, you determine and improve the safety management system, the system. So you set the overarching policy on this. And that has then to be implemented by the RSR staff. So those are very specific functions. There are certain appeals, we'll get to the appeals a little later, that the board will deal with, or a board committee at least. There are certain ministerial instructions that you will have to comply with. And it's always important when you receive a ministerial instruction to check that the minister actually has the power, because the minister is an organ of state and therefore can only do those things that he or she is empowered to do. So it's another thing to look at. Advise the minister and parliament on the efficacy of the act. We now have a new act, and it was drafted after intensive consultation and a lot of thought and time went into it. But legislation is never perfect. And as a draftsperson, I will be the first one to admit that. Never have we drafted legislation that is perfect. So if there are areas that need to be improved, you have a function where you can bring it to the attention of the minister and to parliament if you need to. You approve the strategy, importantly the budget, the action plans, and the organogram of the RSR. Because you are accountable for the actions of the RSR, you will determine what is the framework, how many people do we need to do the job of the RSR? What type of people do we need? In what positions? What skills must they have? What are the remuneration levels? So that's a specific duty of the RSR, is to determine the organogram, because later on you'll see that the CEO has the power to appoint the staff. That's not a board function. But the CEO can only appoint people in accordance with this organogram. So that's the way you control that particular aspect, is you say, this is the organogram, CEO, you go out and appoint the staff in accordance with this organogram. And obviously, it is always open for the board to be advised by RSR staff and ask them, give us proposals, but the ultimate decision lies with the board. Disqualifications, I'm not going to go into this in detail. There's a list of people who cannot be members of the board. There are certain things where board members have a particular attribute or a lack of that attribute which disqualifies them. So there are a number of them. But importantly, there's this one. You cannot serve on more than 3 boards, and that includes private sector boards as well. And the reason for that is obvious. We don't want you to be overloaded. You need to pay sufficient time and attention to this particular organization. Not in the employ of or is remunerated or receives any benefit from any safety permit holder. I think it speaks for itself. And then another one that I've listed there, failure to declare business interests. And from time to time things, I mean, you have a life outside of the RSR, you have business interests. Just make sure that they don't collide with your fiduciary duties here as a board member. And we have a process, if it does happen, because maybe today you don't have those interests, but over time. And it doesn't only affect you, but also what we refer to as associate persons. And there's detail in the Act on who do we regard as associate persons. If your spouse, for instance, holds shares in one of the operators, and that operator applies for a safety permit, there might not be a direct conflict of interest, but it's the perception of a conflict of interest. And people will say, well, you know, one of the shareholders' husband or wife is a board member of the RSR, so obviously we'll get a safety permit. So it's that perception that we're also looking at. And when you are appointed, obviously those things cannot apply, but 1 or 2 of them can actually only happen at a later stage, once you've already been appointed. So just be aware of your business interests and those of your associated persons. And if it does arise, we'll get to the process a little later. Conflicts of interest. Prior to the appointment of a new board member, they must give it a written undertaking or indicate to the minister who appoints them that none of the disqualifications apply. Then if it happens that there might be something that comes up that indirectly affects your position as a board member, then you simply recuse yourself from that board member, inform the chairperson to say that I might have a possible conflict, so I will wait outside, I will not vote on the issue, and when the issue has been dealt with, you return to the board meeting. I think those are fairly standard provisions that we have. And then the important one, if a conflict does arise after you've been appointed, you inform the chairperson immediately. Coming back to the principle of government in the sunshine, you inoculate yourself against all kinds of allegations by going to the chairperson saying, this is a possible conflict, how do we deal with it? And because it's open, it's transparent, it can be dealt with. The chairperson has investigative powers, so the chairperson might say, please give me more information, or I want to check on whatever the case may be, and then deal with it. That is one of the roles of a chairperson of a board. So there is a mechanism to deal with that. Then on meetings and committees and delegations, I'm always a proponent of not being too prescriptive, but you know, I draft what I'm instructed to draft, so we have a few provisions there, but I don't think any of them are specifically onerous or difficult to deal with. We deal with a quorum, and what happens if there's not a quorum. So all of that is dealt with. What is the decision? It's a majority vote. The chairperson has a decisive vote, a casting vote in respect of equality of votes. And then important, no person other than a board member or a person rendering secretarial services to the board may be present during a board meeting unless he or she was invited by the board to attend a specific part of the meeting and for a specific purpose. And the reason for including that is we've had activist groups saying, well, we want access. We want to sit in on those board meetings. And whilst we cherish the principle of government in the sunshine, you are going to deal with many very sensitive issues that need to be kept confidential. Because remember, the Promotion of Access to Information Act applies, but also POPI, the Protection of Personal Information. If you, for instance, talk about promotions in the RSR, it affects the lives of real people. And it's not information that you need, that you are even allowed to spread all over the public domain. So there's a reason for why we say nobody's there unless there's a specific reason. And you determine whether it's a good reason or not. If it is a good reason, then by all means. So it's flexible again. It's in your hands to decide on who is there and who isn't there. You may delegate functions, but the minister may, by regulation, limit that power. I don't really see any reason for that to happen, but again, it's flexibility. Also remember, when you look at legislation, when we draft legislation, we're not drafting for today. We're also drafting for over 20 years. And we need to make provision for things that could happen in the future. And that is why we say the minister could limit your power to delegate for whatever reason might be reasonable in that particular instance. Termination of board membership. First of all, you can resign. Whatever your good reasons are, ill health or other business interests or appointment somewhere else or whatever the case may be, you can resign in writing 1 month. You resign by letter to the minister because the minister appoints the board member. But of course, as a courtesy, you will also inform your chairperson and the other members of the board. Then the minister may also terminate your membership, but only after due process, which means that, let's say the minister says, well, your spouse has an interest in a particular operator, and I think there's a conflict of interest. Then there's a due process. The minister will inform you that I think this is a problem and I think you ought to resign, or in the absence thereof, I shall terminate your membership. But you have the opportunity to provide reasons why I should not do that. And then you go through that process, administrative justice, and the minister then takes a decision, either not to terminate or to terminate. But then importantly, the minister must provide reasons. Now that is already actually administrative law, but we emphasize it here. So the minister cannot lightly just fire a board member because he or she doesn't like that particular board member. There must be valid and good reasons why that happens. If there's a disqualification, the member must inform the chairperson and the minister needs to know because it's the minister who appointed, and the minister is accountable to Parliament for his or her board that he or she appointed. So the minister must be appointed, and they will then take a decision whether or not to terminate membership. And when terminating membership, the minister must inform Parliament. Again, we have the balance. So the minister has strong powers, but the minister must also account for it. So that is the process there. Then board dissolution, and we've had examples of that in this country, where the minister just fires the whole board. Or in other instances where the board resigns en masse. All of those things can happen and have happened, and therefore we need a process to deal with that. Now, if the board refuses or fails to perform its functions, the minister may fire the whole board, and that's what we refer to as a dissolution of the board. Again, we've had experiences in that regard where boards simply didn't do their job. And the minister who's accountable to Parliament for the board then says, well, if this board doesn't want to do its job, then I've got to let it go. And that then happens. Again, there's a process. Then secondly, if the Auditor General has for 2 successive years qualified the audit report, the Minister may dissolve the board because it says, well, we now for 2 years in succession have had a problem with the board not ensuring that the organ of state meets the requirements. It might be wise to appoint a different board who will make sure that the RSR meets the standards. So it's in the discretion of the Minister. But again, the Minister must provide reasons. Or what we say is good grounds. Now, people always say to me, what does this mean? The term or the phrase good grounds has been interpreted extensively in court judgments. And I don't want to bore you with all the details, but what it basically boils down to, in a particular set of circumstances, if it's the wise thing or the right thing to do, that will constitute good grounds. Now, I don't want to go into detail, but it's a possibility, again, flexibility, to ensure that there's a good board in place. And then just to make sure that there's a smooth running, the Minister may appoint an interim administrator. You may recall a few years ago at PRASA, the whole board was fired and an administrator was appointed, which raised some eyebrows because it was a question of, is it correct to do so? Does the Minister have that power? In this instance, no raising of eyebrows because we have specifically said the Minister may do so, but we've limited it to 6 months simply because it's not a situation you want to run with indefinitely. Then the CEO. The board must, after having followed an open and transparent process and consideration of all the applications received, submit the names of the 2 most suitable candidates to be appointed as CEO to the Minister. So in practice, what will happen? The CEO position will be advertised. Persons may apply for it. The board will discuss those applications. And the board will then shortlist 2 people. Say these 2 people are the most suitable for appointment. Your letter will go to the Minister to say these are the 2 people and these are their CVs and these are their attributes, etc., etc. And the Minister will then make the final decision on who the person is. And the Minister will then take the decision. Obviously, again, the Minister is accountable. The CEO must qualify to be a board member. So those list of disqualifications will also apply to the CEO because the CEO is also a member ex officio by way of his or her office, a member of the board. The term of office will be specified in the letter of appointment. There's no prescriptive time in this act. The Minister may also discharge the CEO on good grounds. A number of grounds are listed there. And obviously, if that does happen, labor law applies, all of that. It's not a question of just picking up the phone saying you're fired. That's not the way things work in this country. So that is important to know. But although the Minister appoints, the CEO accounts to the board. So the CEO must explain, why did I appoint person X for that position? Why did we not issue a safety permit to that applicant? Why did we do this? The CEO explains to the board. And why is that? That is because ultimately the board is accountable to the Minister and Parliament. So the board must be in a position to explain why something happened. If the Minister picks up the phone and says, well, my buddy applied for a safety permit, why did he or she not get it? The board must be able to give reasons, and those reasons will come from the CEO and the people who work with that. And they will be, hopefully, good and valid reasons. So that's why the CEO accounts to the board. The function, the duties are listed. I'm not going to go into the detail. And when there's a vacancy, the chairperson of the board can designate somebody to be the acting CEO. So those are the provisions applying there. On the RSR staff, remember, the board determines the terms and conditions of employment and also the organogram. How many inspectors does the RSR need? The board will determine that. Does the board need a whatever position there is, the board will decide whether it's a good thing or not. And again, for the organogram, the board is accountable to the minister and to Parliament.